Great. Welcome, everyone. First, we'd like to thank Elder Constance Simmonds and our panelists, Professor Kerry Wilkins, Joel Morales, and Candice Telfer, and of course, all the participants for joining the Indigenous Initiatives Office and Asper Center panel on Section 35 and the duty to consult. And a special thanks to Amanda Carlene and Tal Schreier for their support of this panel, and also to the Law Foundation of Ontario for their support of the Indigenous Initiatives Office Speaker Series. First, we'd like to acknowledge the land on which the University of Toronto Faculty of Law operates. For thousands of years, it has been the land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River. Today, this meeting place is home to many Indigenous peoples from across Turtle Island, and we are grateful to have the opportunity to work and to learn on this land. We also know that people are tuning in from all over today, so we encourage you to visit the link that we're going to be putting in the chat right now to learn a little bit more about the history of the land that you are currently on. So before we jump in, just a very brief overview of the way the panel will proceed and a little bit of information about how to go about asking your questions of the panelists. So first, we are extremely lucky to have Elder Constance with us today, and Elder Constance will be opening the panel. Then Professor Wilkins will give a brief introduction to our topic, and we hope all the participants have had an opportunity to read or at least look at the primer that was sent out with the Zoom webinar link. Professor Wilkins will then lead the discussion with our panelists. For the last 20 minutes or so, we will open up the discussion for questions from the audience. And finally, we look forward to hearing Elder Constance's closing words and thoughts. And in terms of asking the questions, please use the Q&A function that's at the bottom of your screen. You can put your questions there and we'll try to get to as many as possible. So now I'll quickly introduce our fantastic panelists. Professor Kerry Wilkins, who's the moderator of this event, is an adjunct professor teaching Aboriginal law subjects at the University of Toronto Faculty of Law. Professor Wilkins is a recovering government lawyer and has written one book, edited another, and published articles in several Canadian law journals on Canadian Aboriginal law, constitutional law, and legal education. Joel Morales is an associate at OKT, the law firm. He is a member of Cowichan Tribes First Nation, located on Vancouver Island. He graduated from the University of Ottawa with both a Bachelor of Arts and a Juris Doctor degree. After law school, he articled at Aboriginal Legal Services, a legal clinic in Toronto that serves the Indigenous community. Candice Telfer is the Legal Director of Indigenous Affairs Ontario. After articling with the Constitutional Law Branch of the Ministry of the Attorney General, she has provided legal counsel across several provincial ministries and organizations. She is an instructor of constitutional law for this university's Global Professional Masters of Law program. So now that we've been introduced to our panelists, I will pass it over to Elder Constance. And Elder Constance Simmonds is a Cree Métis knowledge keeper and pipe carrier with over 40 years of experience providing addictions, mental health, and trauma counseling. Elder Constance has served as a senator of the Métis Nation of Ontario, a member of the Indigenous Advisory Group to the Law Society of Ontario, an elder in residence at Women's College Hospital, and a member of the University of Toronto's Council of Aboriginal Initiatives Elder Circle, among many other things. And since 2016, Elder Constance has been working with the Faculty of Law to support Indigenous students and to help settler students learn more about Indigenous epistemologies and laws. And Elder Constance is currently the faculty's elder in residence. Thank you very much, Elder Constance. I pass it over to you.
Jimigwich, and I want to say Tanse, Siko, Ani Boshu, and Mayo Kisika, and extend all our warm greetings to all of you. And thank you for taking the time to sit with us. And I want to uphold Professor Kerry Wilkins and our two panelists, Candice and Joel. And thank you that you're bringing your knowledge to us. This is really important knowledge, and I look forward to how I'm going to learn and grow from this experience. So from my heart to yours, Chimigwich.
Thanks very much, Elder Constance. You got us started in an excellent way. It falls to me to give a very brief overview of the law on the duty to consult. I assure you it's much more complicated than I'm about to make it seem. But at least you'll have some basic orientation about what we'll be talking about for the rest of the time. So in a case called the Queen against Sparrow in 1990, the Supreme Court of Canada clarified that Aboriginal and treaty rights, once we know what they are, prevail over legislation and government action that infringes them unless the Crown can justify the infringement. And that consultation before the infringement took place is at a minimum highly relevant and quite possibly necessary to successful justification of any infringement of an Aboriginal or a treaty right. So we've known since at least 1990 that it is at a minimum prudent for the government to consult before infringing Aboriginal or treaty rights. But that left unresolved at least two important issues. The first one is, what do you do in a situation where an Indigenous community has claimed an Aboriginal right and given reasons for its claim, but has not yet had an opportunity to prove in court whether the right exists, and has not yet succeeded in negotiating a resolution of the right claim in a treaty? That's the situation that came up in the Haida Nation case in 2004. So the Indigenous position in the Haida case was that everything should stop and wait until the claim was resolved. The Crown's position in the Haida Nation case was, you haven't proved you have an Aboriginal right, and unless and until you do, we can go about business as usual and we don't need to worry about you. And the Supreme Court of Canada, not surprisingly, rejected both of those views. It said quite clearly, and has maintained consistently since, that Indigenous peoples do not have the capacity to veto Crown conduct or decision-making. But it said to the Crown, you can't just do whatever you want to do in blatant disregard of Indigenous concerns about this possible Aboriginal right. You have to show some respect for it. The honor of the Crown demands it. So in order to split the difference between these two positions, the Supreme Court essentially made up the notion of a duty to consult, which it derived from an ancient notion called the honor of the Crown. So the duty to consult, I'm going to say this twice because it gets complicated. The duty to consult arrives as follows. The Crown has a duty to consult a given Indigenous community when it is contemplating conduct that, to its knowledge, might have an appreciable adverse impact on an Aboriginal or treaty right that that community has or credibly claims. I'll say that one more time. The Crown has a duty to consult a given Indigenous community when it is contemplating conduct that, to its knowledge, might have an appreciable adverse impact on an Aboriginal or treaty right that that community has or credibly claims. Second issue that remained unresolved after Sparrow is, what about situations where something the Crown does or is thinking of doing might have an adverse effect on an Aboriginal or a treaty right that does not quite rise to the level of infringement, or that might even be explicitly permitted by the terms of a treaty. That was the issue faced for the first time in the first Mikisew Cree decision in 2005. In Treaty 8, the Crown had the power to take up surrendered lands that had been used for treaty harvesting rights at the expense of those rights. So taking up land is not ordinarily an infringement. But even so, taking up land does or certainly can have an adverse impact on the exercise of those harvesting rights. And in the first Mikisew Cree decision, the Supreme Court said that although the Crown can take up land without infringing the treaty right, it has an obligation derived again from the honor of the Crown to consult with the Indigenous communities whose treaty rights would be adversely affected about the proposed taking up before it actually takes up the land or even decides whether to take up the land. So you have three features of the test for the duty to consult. You have Crown knowledge, you have Crown conduct, and you have potential for adverse impact. So Crown knowledge means the Crown has knowledge either of the right, and treaty rights are public, so the Crown has knowledge of all treaty rights. And if the Crown has accepted a claim for negotiation, the Crown is deemed to have knowledge of the claim and to have conceded that the claim is sufficiently credible to consult about. But generally speaking, if an Indigenous community has made a claim to the Crown has knowledge of the claim and must take it into account when contemplating conduct that might have an adverse impact on the right that the claim is about. Now, Crown conduct, we now know, does not include legislative activity, but probably does include regulation making. It also includes decisions the Crown is making, approvals the Crown has been asked to give of private activity that might adversely affect Aboriginal or treaty rights or credible claims. And Crown conduct does not have to have a direct impact on the Aboriginal right. The duty to consult can arise even in respect of what the Supreme Court calls strategic higher level decisions that may set the stage for subsequent direct adverse impact on an Aboriginal or a treaty right. And Crown conduct can include the conduct of arm's length government agencies such as tribunals or boards or other Crown agencies that, in the Supreme Court's words, act in the place of the Crown pursuant to statutory authority. So adverse impact, first of all, has to be appreciable. There's a de minimis threshold below which impacts will not trigger the duty to consult. And there has to be a reasonable anticipation of appreciable adverse impact. Mere speculation or guesswork that maybe this proposed Crown conduct could somehow have an effect on an Aboriginal or treaty right is not enough to trigger the duty to consult. But as long as there is a reasonable anticipation that adverse impact might result, you're in duty to consult country. And again, the adverse impact that results from the proposed Crown conduct doesn't have to be immediate. It can again be at the strategic higher level decision-making stage. Now, there's some conflicting lower court law about what that means and how that works, but the Supreme Court has been clear that even higher level decisions that create a context for subsequent adverse impact suffices to trigger the duty to consult. So what does the duty to consult require? Well, that depends on the circumstances. There is a spectrum of different possible degrees of obligation that relate to the duty to consult depending on the circumstances. And according to the Supreme Court of Canada, we decide the scope of the Crown's duty to consult, what you might call colloquially the standard of care in consultation, by taking two considerations into account. In the Supreme Court's words, you decide the scope of the duty in a given case based on a preliminary assessment of the strength of the claim of Aboriginal right, its prima facie merits, and the likely severity of the adverse impact on the right that the community has or is claiming. Now, in my experience, the more important of those two in determining the scope is the second one, the severity of the adverse impact, because there are Supreme Court of Canada decisions that involve established, acknowledged treaty rights where the duty to consult has still been held to fall at the low end of the consultation spectrum. So I think the issue of the prima facie merit of the claim can operate to discount the scope of the duty, but not to supplement it. More depends on the severity of the potential adverse impact, assuming you have a credible claim to begin with. Now, at the low end of the consultation spectrum, the Crown has to give the Indigenous community notice of the claim. It has to invite comment. It has to indicate its own best initial view of the adverse impact that might result on the right or the claim. It has to give the Indigenous community an opportunity to comment, and it has to take some account of the Indigenous response to the consultation opportunity in deciding what to do and how to do it. At the upper end of the consultation spectrum, the Crown is expected to engage in what's called deep consultation, which can require formal participation in decision-making on the part of the Indigenous community. It can require something like hearings, an opportunity to make formal submissions to the Crown. And it can and often does require the Crown to give written reasons that indicate that and how it took account of the Indigenous input in making its decision. In some situations involving deep consultation, the Crown also has a duty to accommodate the Aboriginal or treaty right or claim by modifying to some extent what it was proposing to do or to approve to take into account the Aboriginal or treaty right that's in play and the Indigenous community's concerns as expressed through consultation about potential adverse impacts. And I think that's the best I can do in the amount of time that I have to give you an overview of how the duty to consult works. Ideally, we talk a bit about the standard of review, how courts review Crown consultation when it's challenged in court, but that would be a complicated discussion. If you're interested, you can ask a question about it. But in the meantime, we have some questions for the panel that we can discuss as a group. And then you'll have an opportunity later on to ask us any questions you have about our discussion or about the duty to consult. So, hi Candice and hi Joel. So the first question I want us to think about is this notion of a preliminary assessment. Supreme Court said the scope of the duty to consult is proportionate to a preliminary assessment of the strength of the claim and the severity of the potential adverse impact. So some lower courts have held that the Crown failed to meet its duty to consult because it did not conduct a preliminary assessment of the strength of the claim or the severity of the adverse impact. And sometimes have failed to share their preliminary assessment with the Indigenous community to give the Indigenous community an opportunity to correct it. On the other hand, there are Supreme Court of Canada decisions about consultation that have suggested that what really matters is whether the Crown has consulted sufficiently, and that it's not always necessary for the Crown to conduct what the court calls a formulaic Haida analysis in order to reach sufficient consultation. So how should we think about this notion of a preliminary assessment, and who has to do the preliminary assessment? Is this something that is a necessary part of the consultation exercise or not? If, for example, the Crown decided as a matter of policy that it wasn't going to bother with preliminary assessments, but it was going to engage in deep consultation anytime it consulted, would that be good enough if it actually did consult sufficiently? Or would its consultation efforts be vulnerable merely because it had not conducted a preliminary assessment? Joel, why don't we start with you?
Thank you, Professor, and thank you, Elder Constance, for opening us in such a good way. With regards to this question, I think it does raise an interesting point, and in terms of the preliminary assessment, certainly from representing First Nations clients, my perspective is that if there is going to be a preliminary assessment, the First Nation or the Indigenous group should have a say into what goes into that. Certainly in our practice, we've come across cases where development is planned to be done in a specific territory, and it's not known to anybody because of colonial practices that there's a sacred site where the development is supposed to be had. And so if the Crown were to just come up with the preliminary assessment by itself, it wouldn't be aware of that. And the knowledge had been kept specifically because they were worried about violations that could occur to the land. So I think that in order to, if there is going to be a preliminary assessment, that it shouldn't just be up to the Crown to determine or to dictate to the Indigenous group what their assessment of what their rights are going to be, that they should be involved in helping kind of contribute to what the consultation should look like right from the outset, and that would kind of help frame it better for all the parties involved. Yeah, I'm not sure if Candice would like to speak more to her perspective.
Sure, thanks, Joel. And yes, thanks, Kerry, and thanks so much, Elder Constance. It's always a pleasure. I want to engage with the questions that Professor Wilkins and Joel have put forward. Before I do that, and I apologize to anybody if this is the first time you're watching a panel with a government lawyer, but this is always the thing that we have to do, so bear with me. But I do need to do a quick disclaimer and say that everything I'm going to say today in this panel is represents my own views, not the views of the Attorney General or the Minister of Indigenous Affairs. So while I'm really happy to be here and bring a government lens to some of these issues, and I look forward to speaking frankly and openly with all of you, please don't turn around and try to sue the government based on what I say. I'm speaking on my own accord. So, okay, that's that little piece of housekeeping out of the way. So Joel, you sort of reminded me that, I think it's helpful to go back to first principles a little bit when we're looking at these questions. So as Kerry laid out at the beginning, right, we know that the purpose of the duty to consult and accommodate is really about preserving assertions so that rights aren't ultimately stripped of any meaning before they can be proven in court. But more importantly, I think it's also about promoting engagement and negotiation between Indigenous communities and government decision makers. And to me, how I sort of, think about that is it really is an iterative process between government and communities. So information really does need to be shared so that if there is more information, as Joel was suggesting, that the government may not be aware of or that may not have come to the Crown's attention, Indigenous communities need to be given opportunities to fill those gaps. So transparency, I think, is critical in the process. I think the challenge here is defining what we mean by a preliminary assessment. And I think that means different things to different people. So I think where we're going to sort of run up against the edges of my comfort on this is that, I think for a lot of people, the preliminary assessment means the legal assessment, the legal advice that the Crown is getting on the strength, particularly on the strength of assertions. Now, I take the view, and I know this is controversial, and Joel, I'm very happy if you want to sort of push back on this, you may take a different view, but I take the view that the government is not required to provide its legal advice. I think every client, including government clients, are entitled to privileged legal advice for a number of reasons I won't get into, but I'm happy if there's questions about that. But and I also just want to acknowledge, I know that the Truth and Reconciliation final report includes a recommendation that this legal advice be made public. So I am sort of out of step in terms of where the TRC came down on this. But that said, so putting aside that and assuming we're not talking about the legal advice, the legal assessment, I think there is a lot of information that can be shared that is short of the privileged legal advice. And ultimately, the government's position on consultation in any given project is, at the end of the day, a policy choice that may be informed by legal advice, but it is a policy choice of the government. So, I think there's information about the facts that the government relied on, the factors that are in play that can be shared. And the last point I'll say, and sorry, Professor Wilkins, I know I'm going on a little bit, but the last thing I would just say is, and I think Professor Wilkins made this point really well, is that there may be a lot of considerations that go into the Crown's position on consultation, particularly if we're talking about deep consultation, that may be informed not just by the Haida Nation analysis, the legal analysis, but there might be relationship, political, socioeconomic, all kinds of considerations that go in. If we work from the place of that preliminary legal assessment in particular, I do worry that that may undermine the larger government to government relationship. Legal positions tend to become intractable and lead to intractable positions. So I would worry it might be counterproductive to a certain extent. I've gone on a little bit, I'll stop there.
Joel, thoughts in reply?
Yeah, so thank you for sharing that, Candice. I think one reply would have, in terms of, certainly I would agree that every lawyer, including government lawyers, are welcome to privilege, and you have your own kind of confidential information that you have to protect as you're providing services. But here, when we're talking about Aboriginal rights, like the honor of the Crown is always at stake when dealing with Aboriginal peoples, and in terms of kind of fostering a good relationship and kind of helping frame the consultation procedure correctly and fairly and most expeditiously, it may well be in both parties' interests or in the government's interests in this case to kind of make a full disclosure of its preliminary assessment of the claim, and that allows the claimants to kind of respond to it as the consultation.
Okay. I'm brought to mind the Beckman and Little Salmon Cormac's case, where the Yukon denied throughout the legal proceedings that it had any obligation to consult anyone about the decision that was at stake there. And the Supreme Court of Canada said, no, you're wrong. You did have a duty to consult, but you managed to satisfy the duty to consult, despite having denied throughout that you had a duty. Now, it's highly unlikely in that case that the Crown in Yukon would have done a preliminary assessment of the claim, but nonetheless, its consultation was deemed to be sufficient. So, is it necessary to do a preliminary assessment? It may well be good practice. There may be reasons to do it. But is it a matter of legal or constitutional necessity, do you think? Anybody have a thought about that?
I guess I will just sort of jump in to say, I think, I think this is an area where definitives are probably a bit dangerous. I don't know if I would say yes for all time and in all circumstances. I find it hard to imagine circumstances where there isn't at least some degree of a preliminary assessment underway. But that being said, and something I sort of believe more and more, I worry sometimes that we do get tied up in the legal regime and ignore the kind of larger reconciliation-based, relationship-based political implications. To the question, as you posed it originally, Kerry, you said, if the government is prepared to engage in deep consultation regardless, there would be a number of reasons behind that. So again, I would sort of ask, why would we be risking letting the legal assessment create a ceiling in terms of the government's response, rather than accepting that the legal assessment and the legal obligations may just be the floor? And don't we want to promote government-to-government relationships? Don't we want to promote reconciliation and promote as much deep engagement as we can get? So again, I kind of come back to the question of, is there a risk of this being counterproductive? Joel, you might have a different view on that, though.
Thank you, Candice. Yeah, I think that if there is going to be deep consultation in every case, then there may not be the need for the preliminary assessment. But I think generally in our practice, it's kind of nice to kind of know from the beginning what is going to be happening and what the Crown's position is in terms of consultation. In our experience, that, I don't know, in terms of always being able to have deep consultation is a lofty ambition, and there are time and financial resources limits on both sides. But I think it is something that, again, I would hesitate to be definitively, but I think generally it would be a good idea to be able to provide those assessments and have the First Nation be involved in helping with their creation.
Okay, thanks. Let's move on to another question. There are lots of things that the Crown needs to consult with particular Indigenous communities about, because there are lots of different ways in which Crown conduct might adversely affect a given Aboriginal or treaty right, existing or credibly claimed. So I sometimes worry about consultation with a vengeance with a particular Indigenous community being flooded with consultation opportunities. And as a general rule, Indigenous communities have limited resources and substantial demands on those resources within their communities, even before you get to the exercise of consulting, before and apart from that. And participating meaningfully in consultation can be time-consuming and expensive. It can involve hiring experts to give reports to participate. It can involve hiring counsel to assist in making submissions before tribunals and other kinds of stuff. And Indigenous communities, despite having the opportunity to do all that, may not on their own have the resources to participate meaningfully in consultation as often as they would like to. So the question, I guess, is to what extent does the Crown have some responsibility? To what extent does the honor of the Crown require the Crown to facilitate Indigenous participation in a meaningful consultation process by providing resources or funding to help enable effective Indigenous participation? Candice, can we start with you on this one?
Sure. So I think the starting point is, the obligation, and the courts have been clear again and again and again about this, that consultation has to be meaningful. I think governments now, I know this has been, this is a contested area, but I think governments are generally aware of that fact. And I do think that there is sort of capacity funding. I know both the federal government and the Ontario government do have programs and capacity funding specifically for consultation purposes. Now, there may be a whole different question about whether that is sufficient and whether sufficient capacity funding is provided. To my knowledge, and Professor Wilkins, you will correct me if I'm wrong on this, but to my knowledge, I don't think the courts have found a specific obligation to provide capacity funding, although the courts have reiterated the requirement for meaningful consultation. But again, it's that requirement for meaningful consultation that is critical, and it's hard for me to imagine that some sort of capacity support isn't part of that. This is again a question that I think to a certain extent it's more helpful to look at it from a pragmatic and a policy perspective than a rather strict letter of the law perspective. If a community can't meaningfully engage in consultation, then there's risks for the government, right, in moving forward, not least of which is the court saying that the government did not fulfill its duty to consult, or as Professor Wilkins mentioned, the court saying that the government did not act honorably consistent with its constitutional obligations. So these risks are real from a legal perspective, and they impede relationships, they impede cooperation. And on a very brass tacks level, if you want to just think about it from a sort of cost benefit perspective, they interfere with development, which may be a key goal for the government. So I think the government needs to, and is sort of more and more sort of looking at this from a pragmatic perspective, perhaps more so even than from a, what does the case law tell us is required?
In my reading of the case law, I think, Candice, you're correct. I have not seen a case in which a court has said the Crown has an obligation to fund Indigenous participation in consultation. But from time to time, you see courts commenting on the presence or absence of funding as part of the consultation process. In the Clyde River case, for example, the court commented on the absence of participant funding available to the Indigenous community and ended up finding that the Crown's consultation had not been sufficient. In the companion case, Chippewas of the Towns, the court commented that participant funding had been provided to the Chippewas and ended up concluding that the Crown's consultation had been sufficient. And I'm inclined to think that the presence or absence of funding was a factor the court took into account in its overall appraisal of the consultation. But I have not yet seen a case where the Crown was found to have an obligation to fund. Joel, what's your experience? What do you think about all this?
Certainly, thank you, Professor, and thank you, Candice, for your answer. Yeah, for us, this is an issue that we run into at OKT. We represent clients that often are of limited financial means, and they receive many kind of form letters inviting them to consultations. And it's difficult to just keep up with all of that and to meaningfully engage without being provided some funding to participate in the consultation. And There certainly is the Clyde River case where kind of the absence of funding was shown to, I guess, be an indicator that his duty to consult may have not been met. We also had a case with the Saugeen First Nation where the court said that the expense of the consultation arose out of the proponent's desire to see a project through and the Crown's desire to see it move ahead, and it shouldn't reasonably have expected the First Nation to absorb all the consultation costs from something that the other party wanted to do. And like Candice was saying, I think it's good kind of pragmatically for both parties to kind of come up with some consultation. And as Candice said, there are funds in place at the provincial and federal level to engage in consultation, but the adequacy of such, I think, is where most of the problems kind of come to a head, where the client may want to do its own traditional land use study or its own knowledge keeping study or do interviews with specific people, but the Crown may not think that that's necessary and not provide funding for it. And so then it kind of leaves the First Nation in a crutch where, well, if we say no, we're not going to be able to go ahead with what we want to do. But if we say yes, it looks like we're just agreeing to whatever we've been given. So it does kind of create a bit of a friction there.
So what do you think we should do about that, if anything? Is that a pragmatic problem that the Indigenous clients have to rely on the goodwill of the Crown, or should there be some sort of obligation? Joel?
I think pragmatically for both parties, it would be best if there was adequate funding to engage in the consultation. So I would lean more in that direction rather than making the First Nation choose or whether or not it agrees.
Okay, Candice, last word to you on this, if you have anything else you want to add.
No, I mean, I think Joel has sort of framed up the tension, and I think the word friction is the right word. He's framed that up well. I tend to sort of fall. I think you're going, Professor Wilkins, which is, you know, how do we address this issue? You know, I think a lot of people would agree that more funding will be helpful. But I also wonder, again, if this is something where we need to think more creatively. Is the way that consultation is being rolled out and being undertaken the most efficient way? Should we be taking a broader, kind of more consolidated approach and perspective around consultation that makes it easier on communities? Are there timing issues that the government should be thinking about or communities should be thinking about? So I guess my last thought would be, is it just about funding? Or are there other sort of process and other related issues that we need to be thinking about to address the capacity question?
Okay. Let's move on to another question then. In some Indigenous communities, there is controversy or contest about who legitimately speaks for the community. We saw a year ago in British Columbia with the Coastal GasLink pipeline, a situation where British Columbia obtained the consent of all the elected Indian Act band councils to the pipeline project, but the hereditary Wet'suwet'en chiefs were adamantly opposed and felt they had not been adequately consulted. Similar stuff comes up from time to time in Ontario because there is difference of view within Haudenosaunee communities, for example, about the authority on the one hand of the hereditary chiefs of the Confederacy, and on the other hand, the elected councils under the Indian Act. Now, the Crown has a duty to consult, say, the Wet'suwet'en or the Haudenosaunee. How ought we to think about ascertaining who needs to be consulted on behalf of the Wet'suwet'en or the Haudenosaunee in those examples, in order for the Crown to act honorably and fulfill its consultation obligations. Joel, initial thoughts?
Okay. Thank you, Professor. Yeah, so this is a very timely and relevant question with what we've seen recently and throughout Canada's history in terms of who are the right holders that need to be consulted. And I think that you had mentioned how there's the traditional governance systems, which were interrupted with the imposition of the Indian Act and the Band Council system. So for different communities, this has created tension between the two as to which is seen as more legitimate. And so I think that since it was kind of created by the government imposing this on the Indigenous communities, that they should be allowed to kind of work it out before a lot of these consultation projects happen, so that it's kind of clear as to who the rights holders are. And it is a right owed to all the community members, but it does need to be kind of the most authoritative. And so it's an internal decision, and the Crown should help fund the First Nations to determine who will speak for them, rather than going to whichever group is going to agree with the project or whatever the consultation is about, and saying that since they, or the first group to say yes, that therefore they have the permission from the community to go ahead. But I'm sure Candice has other ideas about that as well.
I'd like to ask a quick question of clarification. It would seem to follow, I think, from what you said, that nothing could proceed that might affect the Section 35 rights of Community X until Community X had resolved to its satisfaction the issue of legitimate authority within the community. And that could take a long time. Are you okay with that?
Yeah, it is a good question, and it would take a long time. In different circumstances, I think it may vary, but I think that Indigenous communities have waited a long time to even be able to be at the table. They've been absent for much of the time, so I think that it shouldn't be a rush for them to have to be seen as holding up projects due to problems that were created by government structures and policies that were imposed on them unilaterally without their consent. So I think that they should be given the opportunity to address this amongst themselves.
Okay, fair point. Candice, I bet you have thoughts on this.
Couple of thoughts on this, and thanks so much, Joel. I do want to start from the same place that Joel started from, and just note that, I think we have to acknowledge that this situation that we're talking about, whether it's with the Wet'suwet'en in BC or the Haudenosaunee here in Ontario, that this is a situation that was created because of colonialism and because of the effects of the Federal Indian Act regime, which displaced traditional governance structures. So, that is where we're coming from, and I don't think anyone can lose sight of that. I think, though, that we do need to think about this in a contextual way, and I don't think there is sort of one answer to the question of who speaks for the community and how the government should respond to that. There are First Nations that have adapted to the Indian Act model, where Chief and Counsel are very well placed to speak for the community, and that needs to be respected and paid attention to. There are other places where a traditional or an inherent governance structure has sort of supplanted the Indian Act model, and that needs to be respected. And there are other communities where the community itself is fractured. So it's sort of not sufficient to say, it's wrong of the government to think of only one or other of these structures as the legitimate representative of the community. The community itself may be divided on that question. So, and I would sort of say I would be uncomfortable in those circumstances, to Joel's point, with the government sort of imposing a view on that necessarily. Again, going back to first principles, consultation has to be meaningful. Consultation is about ensuring meaningful engagement with the rights holding community through its legitimately authorized representatives. So if only one of these governance structures is consulted with, what factions or constituencies within that community get left out? And that's a critical question. I do think the timing issue that you've raised, though, Professor Wilkins, is important. And Joel, I really appreciate the comment that First Nations have been waiting a long time. But I do think, again, on a pragmatic level, there are going to be certain decisions that the government needs to make. Some perhaps not, but there will be decisions that have sort of immediate and broad impacts where that time may not be, that time may be a luxury in terms of the government's view of how much it can hold back. So I think we need to think about meaningful engagement across these divisions in order to move forward.
One option I would think the Crown has when confronted with conflicting claims of authority is to consult with all the different conflicting claimants to make sure it has the benefit of all points of view. And it might ordinarily be in the Crown's interest to do that. It gets a little trickier where you have one of the claimants saying, if you talk to the others, we won't talk to you, and the other one saying the same thing. What ought the Crown to do in that situation?
I assume that question's for me, and I'm going to apologize to everybody if you can hear my cat. This is one of the joys of the work from home situation that we're in. She's very noisy. Kerry, I think you're exactly right. I think there are circumstances where the best answer is to consult across all of the interested groups. And yes, there will be pushback on that. But I think to a certain extent that may be a situation where the Crown has to sort of respectfully disagree and say, no, we're not going to just talk to one of the representative groups. We are going to take the position that we need to talk to everybody who's interested. I would just note, if you don't mind, Professor Wilkins, that this doesn't just happen, what you're talking about doesn't just happen within communities where there are these factions, but we also see situations where one Indigenous community may actually say, we don't think you should be engaging with or consulting with another Indigenous community on a project. So the same, sort of situation comes up. And again, that's where I think the Crown needs to say, what do we need to do? What does the Crown need to do to fulfill its duty to consult? And that may not be what everybody thinks the Crown should be doing, but the Crown has to sort of make best efforts to meaningfully engage per the HIDA test, right? With all of the Indigenous communities who could potentially be impacted by the decision.
Okay, Joel, any final thoughts before we go on?
No, I think Candice articulated that point pretty well. If there are conflicting groups that say, if you talk to the other, we're not going to engage, I think it is up to the government to try and say, like, walk that balance and say that it has the obligation to consult the Aboriginal rights holders. And if they're both claiming to be rights holders, then that may trigger the duty to consult in that instance.
And in my experience, courts don't have a lot of patience for Indigenous communities bringing consultation challenges that are perceived to have folded their arms and refused to eat their vegetables. So saying, we won't talk to you if you talk to them, would not necessarily, from a court's point of view, be effective strategy for an Indigenous community to take, even though there might be principled reasons in terms of the Indigenous law for taking that position. Anyway, let's talk about another question. This might be the last question we have time for, we'll see. There's a lot of talk these days about the United Nations Declaration on the Rights of Indigenous Peoples. Federal government has introduced Bill C-15, which it sees as a step toward implementation in Canada of the UN Declaration as part of Canadian law. As I mentioned before, the duty to consult, as the Supreme Court has conceived it, does not require the consent of an Indigenous community for the Crown to be able to proceed. Supreme Court keeps saying the duty to consult promises a process, not a particular result. Even in the Aboriginal title context, Supreme Court has said the Crown has to seek consent before doing something that infringes Aboriginal title. But if it doesn't get consent, it can still proceed if its consultation has been sufficient and it can justify what it's doing. But in the UN Declaration, there are several places where the doctrine talks about the notion of free, prior, and informed consent being a prerequisite for certain kinds of things. There is a right to have your consent required before certain kinds of things can happen. In other places, consent is referred to in a way that might or might not mean that. So assuming there were to be meaningful implementation of the UN Declaration in Canada, and we can talk about what that means if we need to, what difference do you think the declaration would make to the conduct of consultations once it were in force? Candice, can we start with you?
Sure. And I'm, as I was sort of thinking through this question and how I wanted to answer it, I had a hard time coming up with a way to answer the question that didn't, that may not seem a little bit weaselly in terms of the way I'm going to come at it. But I really do think there is an outstanding and a really big kind of threshold question about what do we mean when we say implementation of UNDRIP. Right. I think as Professor Wilkins pointed out, there's a lot of differing approaches even within UNDRIP to issues like free, prior, informed consent. And of course, as you say, the current legal reality in Canada doesn't necessarily match what UNDRIP suggests. So is implementing UNDRIP just taking UNDRIP and saying, now we're going to put a Canadian statutory header on this and call it a Canadian law? Or does it mean something different? If you look at Bill C-15, interestingly, it looks like what the federal government means by implementing UNDRIP is that UNDRIP, the one sort of active thing that bill does is it says we can use UNDRIP and we should use UNDRIP to interpret our constitutional obligations in Canada. Well, what does that mean, right? As soon as we talk about using something to interpret, there's going to be a lot of different views on that. I think overall, implementing UNDRIP is not a single decision or a single point in time event. If by what we mean in implementing UNDRIP is a process of aligning the principles in UNDRIP with the Canadian constitutional framework, then it makes sense to me a bit more. And I think it has profound implications on how we deal with the duty to consult. But again, I think this is an area where we might be putting too much emphasis on the legal question. And the actual work of implementing UNDRIP is really a matter of policy. It's going to be policy decisions that will implement UNDRIP. Governments will need to decide to change or develop their approaches beyond or outside of what the legal requirements are, because again, the Canadian law and UNDRIP are not necessarily always in the same place. So yes, if governments decide to go that route and implement UNDRIP in that way, it could have really profound effects on how we undertake consultation. I think I'll leave it there. Joel might have much more articulate thoughts on this than I do.
I doubt that, but I think, so thanks for the question and for your comments, Candice. I think I would agree that implementing UNDRIP is going to be a process. I doubt that Canada's legislation will be able to completely align with it overnight, but it is at odds, and the language that has been said about kind of using it to interpret Canada's legislation is makes me wonder how much teeth UNDRIP will have as per Bill C-15, because UNDRIP calls for like the free, prior, and informed consent, as Professor Wilkins said, and this could help kind of address the power imbalance that is a reality in consultation. But at the same time, the Supreme Court of Canada has said that Aboriginal rights holders do not have a veto. So those two I see as kind of being at odds with each other. And it kind of still leaves Indigenous claimants in the crutch where the Crown can outwardly reject their initiatives, but the Aboriginal group cannot stop the Crown initiatives. But pragmatically, I think it is a good tool to kind of help the parties try and come together and hopefully come to some agreement as to what the consultation will look like. Yeah, I think that's that.
Final thoughts on this, Candice? The one thing that occurs to me is that in principle, courts could be taking account of UNDRIP in interpreting legislation already, even without Bill C-15. So if you're right that that's what it does and that's all it does, what's the point? But if you have any final thoughts, and then I think we will turn it back to the organizers, because there are some questions from the floor.
Yeah, I don't really have final thoughts except to say that is exactly the question that I have. At the end of the day, what is the point? Courts, of course, already can, and in fact, courts already are using UNDRIP to interpret provincial and federal legislation. So I'm not sure what the point is, but I will say maybe as a sort of last note on Bill C-15 and whatever the federal government is going to do with implementing UNDRIP. Some of that, I guess, the proof will be in the pudding. We're sort of waiting to see. Bill C-15 also does give the federal government the impetus to start aligning its own policies and laws. What will they do with that? I think that will tell us. But yeah, if you're asking me what's the point, I'm not sure. Hopefully this will be a conversation that we'll keep going.
Okay. I am told we have a number of questions from participants, so let's invite them and do the best we can to answer them.
Thanks very much, all. I'm really learning a lot from your conversations. I have two questions to start that I'll kind of combine from Annie Chan and Brian Hutchins. Annie asks, how is the duty to consult enforced? Is there injunctive relief available? Is it simply a factor taken into account at the justification stage, or is there another mechanism entirely? In your opinion, is this an effective enforcement mechanism, or are there superior alternatives? And I just add on to that from Brian had a question about compensation and whether compensation was a factor at the enforcement stage or a way of accommodating.
I'm going to take a crack at that and then see what the others have to say. The duty to consult is enforceable independently of the justification inquiry under Section 35, because the duty to consult can arise even in the absence of an established Aboriginal or treaty right if there's a credible claim. Usually that's done by way of judicial review. In fact, I can't think of a case where it was done any other way. An Indigenous community challenges a Crown decision on the basis that it was made without sufficient consultation. And the absence of sufficient consultation is what needs remedy. Now, in principle, injunctions are available to prevent Crown conduct from proceeding, and very occasionally have been granted, but it's not the court's preferred remedy. because, as the Supreme Court said in the Haida Nation case, the balance of convenience usually favors the non-Indigenous party. How it reached that conclusion, I'm not sure, but that's what it said. So injunction is an option more usually where a consultation challenge is successful. The court will either issue a declaration that there has not been sufficient consultation, so the Crown knows what it should do differently another time, or it will quash the decision and send it back to the decision maker of first instance to be reconsidered after sufficient consultation. That happened quite famously with the expansion to the Trans Mountain Pipeline. Federal Court of Appeal quashed the original approval of the pipeline, sent it back. More consultation was done. It was approved again. The second approval was also challenged, but this time the Federal Court of Appeal decided that the consultation had been sufficient. In principle, the Supreme Court has said compensation can be available where there has been a breach of the duty to consult. But it's really difficult to think about how you would quantify compensation. What would the measure of damages be, especially in a situation where the result might have been the same, and in a situation where at the time we didn't know whether the Aboriginal right even existed. So in principle, compensation is available in a proper case, but we have a lot of work to do, I think, to figure out how that might work, what that might mean when you're talking about a breach of the duty to consult. Feel free to supplement anything that I said.
The only thing that I might add is just to note, I think one area where this question of enforcing the duty to consult and remedy gets particularly complicated is Professor Wilkins mentioned at the beginning that the court has found in the Mikisew Cree 2018 case that the government cannot be found to have breached the duty to consult in passing primary legislation, but that is a split decision with several Supreme Court judges weighing in, and there's some confusion that's been added into the law about, you know, whether there is a kind of hook after the fact relating to sort of a breach of the honor of the Crown if consultation wasn't sufficient. So you don't have to consult on the passage of legislation, but if consultation wasn't sufficient, it seems now that there may be some kind of remedy to look for after that. But I don't think we have a good sense of what that looks like. Does that fit into the judicial review framework that Professor Wilkins was talking about? Or are we talking about the same kind of remedies? I think that's an area of ambiguity in the law at the moment.
And I'll just add my 2 cents, I guess. And so in terms of injunctive relief available, as Professor Wilkins said, it is rare. I believe there was one case that Okichi represented a client on years ago with Platnex, the KI case. And there were several decisions, but on the first decision, they were able to obtain an injunction for some exploratory work that was going on in Northern Ontario. They did subsequently lose, but it is an example of the community being able to obtain the injunctive relief. And in terms of the compensation, yeah, I think quantifying it is the hard thing, because for a lot of these communities, or oftentimes it is like if it's a sacred site or something for them that's going to be infringed, it is hard or impossible to put kind of a damages amount on it. There is the option of exploring damages or alternative lands, but often it is not easy to come up with a way to quantify how much it's worth, per se.
Next question. Thanks for that.
Thanks all. This next question follows up on something Professor Wilkins mentioned in the introduction, which is on the standard of review. it's a large question to answer in the remaining time, but the question is from Charlotte Butler, who asks if the panel could kind of expand on what standard of review looks like for judicial review of duty to consult, and maybe what it should look like, or how the standard review might be changed.
I have a few thoughts on what it is, and then I'll let you talk about what it should be or supplement what I say about what it is. In the Haida case, the Supreme Court said that questions about whether the Crown has a duty to consult and what the duty requires are ordinarily to be decided on a correctness standard, but that questions about the sufficiency of the consultation, whether the Crown has done enough to meet the scope of the duty, are to be reviewed on a reasonableness standard, so that reasonable efforts to meet the goal would suffice. But then in the Beckman, Little Salmon, Carmack's case, you see the Yukon succeeding in a consultation case, despite having been wrong all along about whether it had a duty to consult. And you also see the majority saying that a decision maker that proceeds without sufficient consultation errs in law, which suggests a correctness standard, pretty much the exact opposite of what Haida had said. And it's interesting, if you look at Supreme Court of Canada decisions, most of the time when they're asked to decide whether consultation has been sufficient, they have not said the Crown's efforts were reasonable. They have said either the Crown's efforts were sufficient or the Crown's efforts were not sufficient. The exception, the exception is the Tunaha case. Now, lower courts have generally followed the Haida template and have adopted a reasonableness standard in looking at the sufficiency of the Crown's efforts at consultation or accommodation. But in looking at all of this today, we have to factor in the 2019 Supreme Court decision in Vavilov, which said that reasonableness is the default standard of review unless legislation itself prescribes a different review, a different standard, or unless it's the kind of issue that goes to the rule of law. And in enumerating kinds of issues that would attract the correctness standard, the Supreme Court specifically mentioned issues about the scope of Aboriginal or treaty rights under Section 35 of the Constitution Act 1982. And in other cases, the Supreme Court has said that the duty to consult is a constitutional obligation. So we don't yet have Supreme Court authority on the impact of Vavilov on the standard of review in the consultation context. Some lower courts have started to wonder about that. But so far, in terms of what the standard is, it's been a bit of a dog's breakfast because the doctrine has been a bit inconsistent and the compliance or the application with the doctrine hasn't been especially consistent even at the Supreme Court level either. So what it should be, I will turn over to the other panelists who probably have smarter things to say about this than I do. Joel?
No, definitely not, Professor. I think you nailed it. In terms of what it should be, I'm also not sure. I think post Vavilov, like you said, the standard of review is unclear. I think it'll have to wait until we get a Supreme Court of Canada decision, because now, yeah, since it is a constitutional matter, does it mean that every judicial review of a duty to consult question is now on correctness? But this goes against Haida, which is still good law. So I'm not exactly sure as to what will happen next in terms of that. So I don't know. I'm sure Candice may have a better answer.
I was tempted to just answer with a big shrug emoji, because I think the reality is that the law in this area is, I think dog's breakfast is the right descriptor for it. I guess I have two thoughts. My first thought is I do think in Vavilov, and Kerry, correct me if I'm wrong, but I do think in Vavilov the court also said constitutional questions will remain questions to be resolved on a standard of correctness. And I think there's an argument that duty to consult related questions are constitutional questions. So is that part of the analysis? On the other side of the coin, when we're talking about sort of the scope and the sufficiency of consultation, I think there's an argument to be made that, you know, those really do fall in the realm of the kind of discretionary decision-making sometimes, in some contexts, not all, where we would typically be deferential to particularly statutory decision makers. So if you're looking at this in the administrative law context on a purely kind of comparative approach, the nature of the decisions being made, then I think there's an argument that these are in the realm of reasonableness. Of course, they are decisions that are being made that have profound constitutional implications. So again, I kind of, you know, the pendulum swings back towards a correctness standard. So I don't know.
In this, as in many other aspects of the doctrine on the duty to consult, the Supreme Court has left itself and lower courts with a great deal of flexibility to reach the results they want to reach in particular cases. And some of the inconsistency in the doctrine may be a result of the court knowing what it wants the outcome to be and finding in the moment a way to reach it. I realize that's a terribly cynical thing to say, but sometimes the reasons you see in decisions are not necessarily the reasons the court reached the result it did. They are attempts to explain and justify a decision that was reached for other reasons that the court may not be telling you about. I hope that doesn't come as a shock to anyone. Next question.
Thanks very much. So I think we're going to pass it over to Elder Constance to share some final words and thoughts. But I'd also just like to thank all of our panelists, and especially in this COVID world, we especially appreciate all the time and effort that you put in before the panel and also today. So thank you very much. And Elder Constance, we look forward to hearing from you now.
Miigwech. I've been sitting here listening and thinking, and what I am struck with is how very learned you are, and to thank you for the knowledge that you've brought to the conversation. These are incredibly complex things. But in my heart, I know that at the center of all of this is the sacredness of the land and the sacredness of the water that sustains all life. And in that spirit, my hope is that all people present here today uphold that thought of the sacredness, the spirituality, and that we are all human beings, and that we all have a stake in protecting the land and the water. And that the knowledge of that helps us to contemplate learning about these laws, learning about these ways, but that our conversation is invigorated, and that the law is a living entity, and the law adjusts to the people of the times. And here we are in the 21st century, and for future generations. These are really important conversations. So I hope that the words that I'm expressing here today are not ignorant to what the center point of the conversation about the law is. But I feel as a knowledge keeper and as a traditional woman, it is upon me to stand up for the land and the water, and that the spirit of the land of Turtle Island is the center point of all our coming together and all our conversations. And now in this 21st century, for all peoples on Turtle Island, but also to remember the ancestors of this land who have the knowledge of the land, and that they be part of the conversation, that the elders and the knowledge keepers, the pipe holders, the ceremonial people who understand the traditions and the knowledge of the land are part of the discussion. So I'm overwhelmed with the knowledge and the wisdom that you bring. And I hope going forward that the conversation continues, and that a renewed commitment to the land and the water is made here through these conversations. So I thank you from the bottom of my heart that you've invited me to participate and learn of these things with a deeper understanding, and go our separate ways, that the words spoken here today will resonate with each individual involved, that they would be stirred to have lively thoughts and lively conversations going forward. And I see all my relations, including the land, including the moon and the sun and the stars and the rocks, the very foundation of our presence here on Mother Earth, all our relations. Matak riash. Hi, hey.
Thank you, Elder, and thank you everyone for coming. That is the end of the panel, and I hope everyone has a great day.
Thanks so much, everybody.